nicely, I fooled you all by promising you popular sovereignty post-1916. I have inserted the paradoxes of constitutionalism in a slight fit of pretentiousness last night. Popular sovereignty, the paradoxes of constitutionalism, and the legacy of 1916. Basically, I want to talk about the concept of popular sovereignty, how it is understood in constitutional legal discourse, and to map some of the tensions inherent in how it is understood in constitutional legal discourse, map some of those tensions, and then link it back to the legacy of 1916. So I'm not going to be talking that much about 1916 directly, but I am going to be talking about how the notion of popular sovereignty that was invoked by Pearse and Co. in 1916, that was very much the leitmotif of the 1916 revolution and subsequent developments. I'm going to analyze that idea, how it's conceptualized and understood in constitutional discourse, and explore some of the tensions that linger in the idea and have affected the development of constitutional legal discourse in Ireland since 1916, 1919, and so on. Very simply, very basically, constituent power, popular sovereignty, is supposed to provide the normative basis for the establishment and exercise of constitutional power, the structure and function of the established organs of the state. It's basic stuff, that the idea that the power exercised and wielded by the constituted organs of state, the organs of state established within a constitutional order, ultimately derive their validity from the consent and approval of the people. The people establish the structures of state power. The legitimacy of state power depends upon and is derived from popular sovereignty. So it's the population, the people of Ireland, who step into the role of the medieval sovereign as the source of all power and validity within a constitutional legal order. The Irish Constitutional Order has been committed to this understanding from the outset. The popular sovereign, the Irish people, confers legitimacy on the organs of the state and can, of course, deny legitimacy to the organs of the state. It's there in the proclamation in 1916. It's there in the Dáil Programme in 1919. It's there in the 22 Constitution. It is there spectacularly in the 37 Constitution, where the point that power is derived from the consent of the Irish people is made repeatedly. The preamble, Article 1, Article 5, and at various other points. De Valera in 1937 in the Dáil debates, summarising what the 37 Constitution was trying to do. If there is one thing more than another which is clear and shining through this whole Constitution, it is the fact that the people are the masters. Okay? This idea, popular sovereignty. As Bill Cassan in the LSE has notes, this represents an interesting break with historic British constitutional theory, which was dying by 1916, incidentally, where constitutional, there's a mistake there, whereas constitutional legitimacy, if you want, sovereignty is vested in the organs of the state. This was the idea, Oren mentioned Hart's rule of recognition yesterday. This is the idea that the state authorities have sovereign power, the Crown in Parliament, and that if you want, this is the way things have been. They are the constituted order of the state. So the monarch is the sovereign in historic British constitutional theory. The people, if you want, come to the state. Okay? Constitutional authority is derived from the sovereign, not necessarily from the people. The people are, if you want, an add-on to the established organs of the state. Already by 1916, interesting enough, that idea was dying in British constitutional discourse, and actually Britain has pretty much joined every other country that I'm aware of, bar maybe the People's Republic of China, in the sense of the concept of constitutional power ultimately is established and derived its legitimacy from the people. Okay? So that now, for example, the sovereign crown in Parliament in UK constitutional theory enjoys that sovereignty de facto because the British people, that is the way in which the background sovereignty of the British people is expressed. Okay? Going back to Ireland, this sort of emphasis on popular sovereignty occurs repeatedly in discourse about the Constitution and political statements and the jurisprudence of the Supreme Court and so on. Gary Jacobson, an American academic writing around 15, 20 years ago, talked about the quasi-religious intonation of this principle as a characteristic of Irish constitutional discourse. And there's a big list of various court judgments where various judges of the Supreme Court wax eloquent about popular sovereignty. The sort of key moment of this being Brian Walsh's judgment in Byrne versus Ireland. There are three, if you want, problems, however, three latent paradoxes, latent tensions irrevocably associated with this concept of popular sovereignty, this lovely idea of popular sovereignty that everyone is committed to. The first problem is the question of who exactly are the sovereign people? Who are this unitary, unified body from whom power is derived? Okay? I mean, Judith Butler has sort of talked about how there's really no such thing as popular sovereignty. It's a bit of a myth that it's actually a cacophony of different voices who may come together at certain moments to sing from the same hymn sheet. But this is an idea that's been lurking around in legal constitutional theory for decades. Again, Oren yesterday mentioned Carl Schmitt. Hans Kelsen, writing against Schmitt, with Schmitt invoking the people, the source of all power and authority. Kelsen famously said there's no people, that there's different interest groups, sometimes allying, sometimes coming in tension, that this idea of a sovereign people is a myth. Now, of course, Kelsen was writing from a sort of liberal position against Schmitt from an authoritarian position. So Kelsen was pushing back against this idea of the sort of the Ein Volk idea that Schmitt was sort of tapping into. Okay? But it's a sort of, if you want, a liberal objection to the idea of popular sovereignty, that there is no people, just an association of different groups. So it's raised the question of who are the people? Specifically in the Irish context, of course, there's always been this issue of do the people of Ireland include our unionist brethren, for example? Who exactly are the people of Ireland? And there's, of course, an ambiguity there in relation to Northern Ireland, which has never been resolved, as to who exactly are the people of Ireland invoked in 1916 and subsequently. Secondly, there's another issue with the concept of popular sovereignty. The problem of the transition to constituted power. Maistre famously commented that the populace are a sovereign that cannot exercise sovereignty, that the people establish the constituted organs of the state, the Oireachtas, the president, the judiciary, the executive, the different arms of the state, and they effectively give away their lawmaking power. They sort of say, right, we no longer rule, we've set the train in motion, now we hop on the train and get carried to whatever destination the driver takes us to. And this is sort of, in a way, has been often presented as an inevitability. You know, that the essence of building a state is that the people use their sovereign power to set up a state at a moment of revolution, a moment of transition, like 1916, and then all of a sudden the state goes away, runs down the tracks, does its own business. And the people sort of disappear from the equation, that they're left out. So if you give an account about how the Irish constitutional order operates, you don't really talk about the people, except in the specific context of constitutional referendums, which I'll come back to. The problem is, of course, that this involves the people giving away power, that there's always an inherent tension there, because the constituted organs of state go away, take the power, leaving, if you want, the people behind. Some theoretical frameworks say the transition leaves an uncertain and undefined surplus of residual constituted power, sort of lurking there, sort of a tension between the people and the constituted organs of state, which, by the way, can include their elected representatives. I'll come back to that. Thirdly, another residual tension in the concept of popular sovereignty is that there's often the idea of the sovereign people often comes with an interrelated and deeply associated second assumption, which is the people are a just lawmaker, like the way the king in medieval times was supposed to be not alone the source of all power, but also to rule wisely. Okay, Aquinas used to say this about God, by the way, if you want a Sunday morning moment, that God was totally powerful, but luckily for everyone, he was also incredibly benevolent, few. But the people, the Irish people, like the people of any other constituted state, are supposed to be a benevolent ruler. It's there in the proclamation in 1916. It's there in the 22 and 37 constitutions. The people give themselves a constitution with directive principles, with rights to establish a better Ireland, a transformed Ireland. The people are meant to be a just lawmaker. So the exercise of sovereign power isn't just an expression of power, of decision. We, the people, are the bosses. We are deciding things, as Carl Schmitt used to frame it in his Nazi years. The people are also, in modern constitutional theory, supposed to be a just lawmaker. They're supposed to create a just constitutional order. There's an assumption that people want a just society, a just, equal society, cherish all the children of the nation equally, and so on, so on, so on, so on. But of course, in establishing a constituent state, you often produce a situation where the constitutional organs of state, parliament, the courts, executive, and so on, fail to rule justly. They exclude groups, they fail to include oppressed, disadvantaged groups, they abuse their powers, and so on, so on, so on. Mary Harrison put it yesterday that the establishment of constitutional power, she didn't use those exact terms, but inevitably excludes and limits. That the establishing constitutional organs of the state, you inevitably have moments at least, or even patterns, maybe even systematic patterns of unjust rule. So as a consequence, the theory of popular sovereignty establishing the state, constituent power is inevitably framed as constituent power, the organs of the state, the state structures established by the will of the people, inevitably is framed as a perpetual falling short. It's always something that sort of never quite hits the ideal of the beautiful state established by popular sovereignty, partially because of the messy nature of popular sovereignty itself, who are the people, partially because of the need to transition to a constitutional power. There needs to be a state structure. State structures are often highly problematic bodies, and because of the tension between the idea that the state established by the people will be just, reflecting the good intentions of the people, but it's often not just. You often have this concept of the state disappointing the people. Okay? And there's echoes there, of course, of Brecht's famous line about, if the people disappoint the state, then we can dissolve the people. But, there's always this idea of falling short. Okay? Now, how does all of this relate? The paradoxes of constitutionalism, as I've classified them. How does this all relate to 1916? 1916 was a radical assertion of popular sovereignty. The leaders in 1916 were effectively saying, the people are not the people of the United Kingdom of Great Britain and Ireland. The relevant people are the people of the island of Ireland. We are asserting our right as a distinct bounded group, separate from Scots, Welsh, and English, and the other peoples of the empire, of establishing our own constitutional order. We are the relevant people for the purposes of popular sovereignty. It represents a radical break with the Victorian, Edwardian, imperial constitution of the UK, which incidentally was undergoing quite radical transformation. It's worthwhile pointing out, as someone who now lectures UK constitutional law, that 1916, when viewed from a London perspective, is part of a continuum of constitutional crises in which the imperial constitution was subject to. You had the radicalism of the suffragette movement. You had the radicalism of the trade union movement. You had events like May 1919 in Glasgow, where troops were called out in the streets against strikers. You had basically the old sort of, if you want, oligarchic imperial constitution coming under serious and sustained pressure and changing quite rapidly. You had Lloyd George breaking the power of the Lords in 1910, and then it changed so dramatically that Labour were minority government in power in London in December 1923. Okay? Something that would have been unthinkable, incidentally, in 1916. Okay? So your moment of huge constitutional transition. And basically, 1916 represented the moment where the people of Ireland got off that train. They basically said, we are not the people for the purposes of your imperial constitutional order, which is beginning to collapse and which doesn't reflect our ethical democratic aspirations. So 1916 represents a pulling back of popular sovereignty to the people of Ireland. Okay? And again, it's the idea of an independent Ireland and a better Ireland. Self-governing Ireland, but also linked in with that, a more just Ireland. The two ideas interconnected. But of course, all the paradoxes of constitutionalism recurred, kicked back into the Irish, arose again in the Irish context, as they tend to arise in any constituted order. First of all, the definition of the people was never resolved. The relationship with unionist population in Northern Ireland was never resolved. And there were wider issues, because of course the depiction of the Irish people, of Irish citizens, implicitly ended up marginalising or excluding social groups in Irish society, women, travellers, persons with disabilities, and so on. I mean, you know this, that the conceptualization of the people was very shaky when it came to disadvantaged groups, and really never has, I think, come to grips with the unionist issue. I once, I think, a very good friend of mine works in Micheál Martin's sort of inner group, and in a discussion over a pint one evening, I sort of cheerfully said, well, of course, the Constitution of United Ireland, the first president of United Ireland, as a concession to the unionists, would probably have to be, Peter Robinson and Áras an Uachtaráin, and we'd have to do something about all the formal procedures being in Irish, because of course he wouldn't be speaking Irish. And it was interesting. My little piece of mischief making triggered a very visceral reaction, I have to say. But that was an interesting example about the type of stuff I get up to in a pub, but also if you want, this uncertain idea as to who the people are and how it always has lingered as a problem in the Irish constitutional imagination. More seriously, the transition from the exercise of popular sovereignty to constitutional power was very, very difficult in Ireland. Because, of course, as numerous speakers made the point yesterday, the revolutionaries of 1916 and subsequent years didn't have a very clearly formulated notion of what the constitution state they were establishing was going to look like. They didn't have a very clear structure as to how their aspirations for greater social justice, democratic self-governance and so on were to be translated into established organs of state. And of course, the establishment of the Irish state was difficult and has been a difficult, long drawn out, messy process. What Adam Bakar in India described as constitutional morality, the importance of a sort of respect for constitutionalization, has been established in Ireland, but democratic ethical responsiveness has been lacking. There's the famous quote from Bulmer Hobson writing in 1956, "The phoenix of our youth has fluttered to earth, such a miserable old hen." And that captures the idea that the sort of phoenix of popular sovereignty, when implemented in the organs of the state, the constitution established organs of the state established, lacked democratic and ethical responsiveness in all sorts of different ways. Now, we can all have an interesting discussion about how badly lacking that democratic ethical responsiveness is. I think most people would probably agree that, yes, that there were gaps and there are gaps in democratic ethical responsiveness. But there's no doubt that the constituted organs of the Irish state as they have been established and as they function over the years, that the gap between the sort of aspirations of popular sovereignty, the aspirations of both democratic self-governance and just self-governance, there's been a falling short. In conclusion, however, these paradoxes of constitutionalism occur in the Irish context like they do in any other constitutional order. But I actually think, and again, as someone, in the UK, very involved in debates of the UK's relationship with Europe, Scotland's relationship with the UK, about human rights and the UK legal order, etc., 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 I'm always struck by the fact that I think Ireland, in a way, popular constitutional discourse, political discourse in Ireland, benefits from the recognition of this gap between the aspirations of popular sovereignty and the constituted order of the state. The gap between aspiration and reality, the sense of dislocation between constitutional power and constitutional forms of the state, between real democracy and constitutional democracy, between aspiration and establishment, that gap is, I think, exists in Irish constitutional discourse, hence, and political discourse, hence the constant references, the constant invocation to, for example, cherishing the children of the nation equally. and the way that's used quite commonly now to sort of critique the established organs of the state and to call for something better. That gap is often productive. Sense of constitutional dislocation is arguably healthy, opening space for democratic dissensus, for sort of challenging the established organs of the state, but it also pushes back against the notion of popular sovereignty being mere politics. The idea of a better Ireland retains potent appeal and invokes through rights discourse and other channels. What I'm trying to get here as a final point is my principal point of contrast with the UK. Because the UK, in my view, often doesn't understand its own constitutional system to itself. The sovereign parliament in Westminster is probably best understood as a permanent constituent assembly in perpetual session. That the people of the UK elect a body that sits as a permanent constitution maker. That's the idea of the sovereign parliament, that Westminster passes legislation which creates law all the time. Okay? So, and this is why, for example, Eurosceptics get so upset at a point of principle about influence from Brussels and influence from Strasbourg and having to dilute power and devolution and all of these things, because they see it as the people's voice, as challenged through Westminster Parliament, being taken away. Whereas we tend to sort of see the constituted organs of the state, who are different from us, in a way, you know, that sort of European human rights protection, European regulations, restricting the power of the constitutional organs of the state. That's not quite the same as them restricting us, though of course there's been recent tensions in that respect. In Britain it's different, but the British system, and I'm finishing now, suffers from this equation. The notion of popular sovereignty is day-to-day politics. That politics, what is done on a day-to-day business by the politicians, is the expression of the popular will of the people all the time. That constitutional power and constituent power in the UK context are equalised. And that, I think, closes down possibilities, arguments for a better state. You know, you can't really point to a division between constitutional aspiration, established constitutional aspiration, and the day-to-day reality of political governance in the UK. That becomes a political argument. You should have a more left state, you should have a more right state. Whereas in Ireland, we're sort of saying we have committed ourselves to a more just constitutional order as set out in constitutional texts, as set out in the 1916 proclamation. That becomes a touchstone for critiquing what happens in our name. Whereas my constant impression about the UK is that that touchstone doesn't really exist. There's a blurring of the lines there, which I think is unfortunate. So 1916 and everything that came with it, constitutionalism, difficult process, popular sovereignty translating into constitutional power, endless paradoxes that occur in any constitutional system, but at the same time there's a huge amount of potential there for sort of radical change, for critique. That sense of difference between the aspiration and the reality is, I think, very, very, very potent and very useful in many ways. Thank you.